All right, Judge Nazarian, the case is ready to proceed.
All right. Thank you, Madam Clerk. Good morning, everybody. You're attending a session of the Court of Special Appeals. As we're all aware, these arguments are being held remotely as a result of the COVID-19 emergency, applicable executive orders enacted by Governor Hogan, and applicable administrative orders issued by Chief Judge Barbera. We appreciate your patience as we have worked through the logistics of holding arguments this month. Since the court is new to using this technology for oral arguments, we had one argument on Friday, but this is really the first full morning we're doing this. So you all get to do this along with us. But since we're new to this, there may be hiccups. If you experience any technical difficulties, please raise your hand to let us know, and we're going to do the same. If we somehow get disconnected, please wait 5 minutes and attempt to rejoin the conference. We'll also stop if we discover that somebody's missing, but there were a couple times on Friday where people lost either audio or video, and we weren't aware of that. So we'll do the best we can if we see something break up, but keep us posted. Madam Clerk is going to keep the time today. She's going to display time cards when you have 5 minutes remaining, 1 minute remaining, and when you have no time remaining. When you have 0 minutes remaining, you may keep going, but you'll be using your rebuttal time, appellants, that is. As usual, if any of the judges continue to ask questions after your time's expired, you may answer those questions. Otherwise, we're going to try to proceed today as normally as oral arguments proceed. Please mute your microphone during the other side's argument if you can, to help eliminate background noise. And if you experience any sort of technical difficulties while you're muted, raise your hand and then we'll take it from there. All right, so Hearns, you're going to start us off today?
Yes, Your Honor. For the record, good morning, Your Honors. Alfonso Hearns on behalf of appellant Dwayne Dease. And yes, that is correct. I will begin today with the first issue. Your Honors, this case arises out of a complaint for absolute divorce filed in the Circuit Court for Prince George's County on July 14, 2017. At trial, the issues before the court were alimony as well as marital property division. At the conclusion of a lengthy trial that was spread out over multiple days, different periods of time over multiple days, at the conclusion of that trial, the court rendered its opinion. Specifically, the court ordered that appellant pay appellee temporary alimony, rehabilitative alimony, rather. The court also ordered 2 residential homes to be sold and the proceeds to be divided equally between the parties. Now, the residential homes that were ordered to be sold, one of which located on Brock Hall Drive, is titled solely in the appellant's name alone. The other property located on Salton Avenue was titled in both parties' names, and the court ordered that both of these parties be sold and the proceeds equally divided. In addition to that, the court also ordered appellant to pay appellee a monetary award in the amount of $100,000. The monetary award was in addition to the sale of each of these residential properties. And at trial, the court indicated in its opinion that the monetary award was granted due to the vast appreciation of the Landover Road property, which was designated as appellant's separate non-marital property. This property, the characterization of the property was not in dispute. The Landover Road property was deemed to be separate non-marital property of appellants by the court as well as each party. Everyone agreed to that designation. Additionally, Your Honors, with regard to the Landover Road property, the court allowed the appellee to, or rather, the court accepted appellee's valuation of appellant's separate non-marital property located at Landover Road And further, Pelly's value was based upon information found on the Zillow.com website.
Did your client agree to that value?
Did he agree to the value? No. In fact,
what was the value set forth in the 9207 statement?
So that statement, I believe,
We can't hear you.
I'm sorry, course brief indulgence. Let me take a look here.
Counsel, you can find it at E413.
Thank you. The value listed on this statement was 334,000.
So your client agreed that that was the value?
No, Your Honor, in all actuality, what occurred was during one of these days in court, this statement had not been prepared. We were probably halfway through trial, and then ultimately the judge said, you'll need to go to the library and prepare a joint statement, and don't come back till that's done. We went to the library, counsel and I believe this is something that she may have already had the template on her computer. She prepared it, and we both signed it, but my client does not agree that that is the value.
How can you say that, counsel? It's the 9207 that's signed by counsel is an admission of the party. There's case law on that. It's the admission, and I'm looking on the here. I thought that this statement was admitted into evidence at the beginning of the trial. At the very beginning of the trial, it was admitted into evidence without any objection. So how can you say that your client will strike that? How can the record reflect that your client didn't agree to it if it's in the 9207, the 9207 submitted into evidence?
I understand, Your Honor. I understand. To that point, yes, it was entered into the statement and entered into the record.
So given that, how could there be any prejudice for the court using that amount for the value?
Well, the prejudice is that appellant during trial did offer actual real estate appraisals that were not accepted into evidence, but the Zillow.com website was in fact accepted into evidence. Now, when it was accepted, I objected to it, but counsel said, well, we're not offering it for the truth of the matter asserted in the website printout. We're just offering it for research that was done. But in the judge's opinion, the judge stated that this is what she relied on for that value, Zillow.com.
Maybe I'm just stuck, but if that what you just described could have happened if it could have been the story if this was contested and you left it for the judge to decide. But once you put it on the financial statement, doesn't that end it? Like, what am I missing?
You know what, Your Honor, again.
I mean, it's signed by both parties. It's represented to the court as an agreement. You're saying to us now, well, the court shouldn't have relied on that. It's not agreed after all. But then the question is, well, what else on that form is not agreed and we can't rely? I mean, that's the whole point of that form, is to put down what everybody agrees on. And if you can't agree, then you have separate forms. But I'm struggling to understand what we're still talking about here.
I understand, Your Honor. You know what? And to that point, I'll just move on. I'll just move on from that point. But the next point would be, thank you. The next point would be that since this property was not marital property, okay, it was non-marital separate property. The only thing I'll say on that point is that the appellee really wasn't in a position to value it. She didn't know the condition of it, hadn't been there in years, and all she had was this website printout. And and I'll move, and that's really all I have to say about that issue.
All right. Ms. Hess, are you going to go next?
Yes, Your Honor. Good morning, Your Honors. May it please the court. I'm addressing issues 2 and 3, and in particular, the award to the appellee of a $100,000 monetary award. The judge's ruling, she, as Mr. Hearn said, ordered that the 2 homes be sold and the proceeds split equally. One of those homes, which I'll address in question 3, is titled only in the appellant's name. The other one was titled jointly. But after ordering these 2 things done and then ordering the parties to keep their own cars, there were 3 automobiles, she then very specifically made a monetary award based upon the vast increase in the Landover Road property, which she even cites, according to Zillow, of over $300,000. Now, as the court knows, the Marital Property Act was instituted so that a party holding title, a spouse holding title, doesn't, basically deprive the other spouse of any interest in that marital property. That was the whole point of the monetary award. We determine what is marital property. We then value that marital property, and then we can make an award from the total of the marital property. And that total of the marital property is the values. The judge does need to determine the values if they're in dispute.
Is it your position that the court cannot consider non-marital property in making a monetary award?
The court can only consider it in terms of this person, husband, let's say, has $1 million account that was left to him by his parents, and it's sitting off there to the side. Now they're divorcing, and there's $50,000 of marital property. The court can say, given that husband has $1 million sitting over there, I'm going to make a monetary award to wife of $25,000, or more than half, the other half of what's marital property.
So why couldn't the court say here that it was going to give the wife a monetary award based on the value of the property in his name?
Because the monetary award can only come from the total of marital property. It is undisputed that that Landover Road is non-marital. It's not part of the pool set for division. A monetary award cannot come from that.
But the court can consider it, correct? And decide what is an appropriate monetary award.
The court can consider non-marital property only in terms of the way described. If there's $100,000 of marital property, but husband has $1 million of non-marital property, the court may find it equitable in certain circumstances to grant the wife most of the marital property, but it can never go beyond the $100,000 total of what marital property is.
Well, isn't that exactly what the trial court did in this case? Isn't that what the trial court considered, the fact that your client had Landover Road valued at $334,000 and entered a monetary award relating to the marital property?
No, Your Honor, because the marital property is the Brock Hall home, which if you look at what husband's valuation was, it was $490. And if you look at what wife's valuation was, it was $580. At best, that would mean that there was a amount of equity somewhere between $123,000 and $213,000. Certainly, it was within the judge's power to make a monetary award, value the Brock Hall property, value Sultan Avenue, and make a monetary award from those totals. What the judge did here was order both of those sold and then made a monetary award based on non-marital property. That clearly is an abuse of discretion. She made a monetary award beyond the value of the 2 marital homes. The 2 marital homes could have been
Get that. If the marital home, if the Brock Hall is sold for her value and Sultan Avenue is sold for her value, isn't the marital property more than, or at least your client's interest in there, more than $100,000?
Yeah, if the judge had actually valued the properties, which she didn't on the record, she did not do so. You're absolutely correct, Your Honor. It is more. But she didn't order that. She ordered those two homes sold and the proceeds split equally. Then she made a monetary award based solely on what she believed was an increase in a non-marital piece of property. More to the point, once it's non-marital, it's non-marital. It's not subject to division. The court can take it into consideration. And
well, she didn't divide it, did she? She didn't order it divided. She didn't order it sold.
It doesn't.
I entered a monetary award, and based upon the $334,000 of no lien, full value property.
But it's not marital property, Your Honor. It can't. Monetary award can't come from non-marital property.
Well, it's not. She's not. She's ordering the monetary award against the marital property. That's what she ordered it against. And as long as there is sufficient marital property to take care of the award, it's completely appropriate.
Your Honor, she didn't make an award for marital property. She ordered the two marital homes sold, and the proceeds split equally. If those two homes are sold and the proceeds are split equally, there is no marital property left except the 3 cars. That's it. So there's no way to grant $100,000.
Isn't there money left over? Isn't there money left over after the 2 homes are sold and the proceeds split?
But that's not what the judge ordered. The judge ordered that the 2 homes be sold and the parties each get their 50%. That's what she ordered. That's what she put in her ruling.
Okay.
Whenever those homes are sold,
is there money left over after that?
We don't know. We don't know what those homes are going to sell for. She didn't value those homes as she is required to do if she's going to make a monetary award. She didn't. She simply said, sell Brock Hall, split the proceeds equally. Sell Sultan Avenue, split the proceeds equally. And this sort of leads into my question number 2, and I realize I'm going to be running out of time. So, Brock Hall is titled only in the husband's name. And the court simply doesn't have the authority to order that property sold.
Well, I would, counsel, I will interrupt you, but I will agree with you on that point. But in the testimony of your client, as well as in closing argument, you agreed that Brock Hall should be sold and the proceeds divided.
There was no agreement about that, Your Honor. The judge made a decision to do that.
Wait, no, your client agreed. I've got the quotation. Look at E 119 to 120. Says, what do you want the court to order today? I guess we're going to split the proceeds from Brock Hall Drive. How soon do you think Brock Hall can sell? I have no idea. Or you don't object to splitting the proceeds? No, not at all. That's your client's testimony.
And Your Honor, I understand that, but she made the ruling already. Admittedly, I wasn't there.
No, that's the testimony. That's the testimony before she made her ruling. Your client agreed that Brock Hall could be sold. It's a closing argument. Counsel, I don't know if it was you or Mr. Hearns, argued that Brock Hall should be sold and the proceeds divided.
And Your Honor, this is what I will say. He's not a lawyer. He doesn't know. He doesn't.
But counsel, in closing argument, asked for it. In closing argument.
I don't believe they did. I'm sorry. I've got zero.
You might want to check 349 to 350. It's right in there. It specifically refers to Brock Hall being sold and the proceeds being divided.
And Your Honor, part of my problem is I have the transcripts with me, not the record extract. When I left Maryland, some of my files are still in Maryland.
No problem.
And I wasn't sure we'd be having arguments today, so I apologize for that. I can't really cite to the fat record extract because I didn't carry that with me.
But do you agree that if counsel agreed, you can't raise that as a claim of error on appeal?
No, I don't, because I don't think that was something that the judge made a ruling. She didn't basically give them an option. She said, this is what I'm going to do. And she did her own order. She had her order typed. As she said, I'm here today, I'm putting it on the record, but I've already done the order, and this is what I'm doing. I'm ordering the 2 homes sold, and I'm saying pursuant to the Marital Property Act, she has no authority to sell a home that's titled solely in one party's name,
But you will
valued it, and then made a monetary award from that.
But you will agree that if the parties agree that the property, which is titled solely in your client's name, can be sold and the proceeds divided, that the trial court does not err if the court follows what your client asked for.
But I don't believe that that was an agreement, Your Honor, and I think there's also part of the problem. Again, I wasn't there at trial that day. I don't know whether his agreement was an informed decision or whether it was just simply he's answering a judge's question. Again, he's a layperson. When I'm looking at this case and I'm seeing that a court ordered a marital home, admittedly marital by the party's admission, but titled in one party's name, that is against the Marital Property Act. It needed to have been valued and a monetary award made. And that's not what happened here.
Okay. Thanks to the 2 of you. Ms. Stevenson, your motion to withdraw has been granted. And so that will be the argument for this case. It will be submitted.
Okay.
Yes,
Thank you, Your Honors.
You all.
Thank you very much.
Bye.